Impeachment is an exercise in political justice, and it can cut both ways, as an instrument of political reform or a tool of political persecution. It needs to meet certain legal standards, but precisely because it is political, impeachment is, in the words of the late great constitutionalist, Father Joaquin Bernas, SJ, a numbers game. The impeachment math starts from really basic arithmetic. How many senators do you really need to convict? Hi, I'm John Nery, and you are in the public square. With the impeachment trial of Vice President Sara Duterte set to begin on July 6, the impeachment math becomes ever more important. I'm happy to say that, to make sense of the numbers, we are joined again by one of the living framers of the 1987 Constitution, who served as a Justice of the Supreme Court and who joins us via Zoom. Justice Adolf Azcuna, thank you for joining us yet again in the public square.
Thank you very much, John. It's my pleasure to join your program again.
Justice, let me begin with the arithmetic of no vacancy. So according to Article 11, you need 2/3. No? As you said, 16 is not the constant number, it's 2/3, no? Yes. Of whatever the denominator is. In your view, we still need 16 votes to convict, despite Senator Jinggoy Estrada under arrest, in detention, and despite Senator Bato de la Rosa in hiding. Is that right?
That's correct, John. In my view right now, as things stand, there are still 24 members of the Senate, notwithstanding that Bato de la Rosa is hiding from warrant of arrest, and Senator Jinggoy Estrada is detained and under suspension because they remain members of the Senate, and the Constitution says 2/3 of all the members of the Senate.
There is another provision, it's slightly similar, for instance, the provision to declare war. No? It should be 2/3 of the Senate and the House voting jointly, if I'm not mistaken. In the case, for instance, if there is an imminent invasion of the Philippines, we still would need to insist on 2/3, even if two of the senators are not on the floor.
The Constitution is usually very specific on the kind of fraction that it needs. For instance, even in the impeachment process, the committee itself says so many votes of all the members of the committee, and also to affirm the articles, 1/3 of all the members of the House. So it says members. When it says members, I believe that even those who are not attending should be counted, because it doesn't distinguish whether or not the members are attending. It's only when it says members present does it exclude those who are not participating.
So this would mean that, okay, let's take the case of Senator Jinggoy Estrada. Even though he's in detention, the fact that he is a senator of the Republic is still a fact.
Yes, Senator Estrada is still a member of the Senate, because detention does not remove a person from office. He's still a member of the Senate, and therefore still part of the denominator. When it says all members of the Senate, the 2/3 must be based on.
What about the case of Senator Bato de la Rosa, who is in hiding? I see, of course, from the posts that you've posted on Facebook and many people follow, at one point you raised the possibility of constructive resignation. Can you walk us through that idea, sir?
Yes, I just mentioned that as a possibility, although there is no doctrinal basis yet for that particular possibility. I just wanted people to know that that's also a possibility, and you cannot totally discount it. But I still think right now that possibility does not apply to him because that possibility entails a declaration, at least by the Senate and probably by the Supreme Court, that the person is a fugitive and therefore has renounced all entitlements under the system that he is repudiating. So
that would need a...
Unless that happens, we're still 16.
For this to happen, you need a resolution from the Senate.
Yes.
But do you also need, as you suggested, for the Supreme Court to come in? Or can the impeachment court, the Senate sitting as impeachment court, already move on and say, okay, we're not counting Senator De La Rosa because we feel that, we think that he has constructively resigned? We still need the Supreme Court?
In the case of the Supreme Court, the possibility there is really what they call doctrine of disentitlement, which merely says that the fugitive cannot seek recourse from the court. It does not really extend to saying that he is also considered resigned, but that is my theory. It's not been validated by any decision of the Supreme Court that this entitlement is just part of the effect of being a fugitive. And a fugitive really is repudiating not just access to court, but repudiating the entire legal system. And that is, if that is the case, then there can be an argument for a constructive resignation.
But even if that were to happen, even if Bato de la Rosa were deemed to have constructively resigned, with a denominator of 23, 2/3 would be 15 point something. In Philippine jurisprudence, in Philippine practice, a fraction above the number 15 brings us to 16.
The Philippine practice is to ignore fractions on the ground that you cannot saw the senator into half or third. So if there's a fraction, you ignore it, whether it's more than half or less than half. So if it is 15 point something, it's just 15.
I see. So in fact, as you said, there is no doctrinal basis yet for the idea of constructive resignation. But if that were to take place, that would already mean a lowering of the 2/3 threshold to 15 because you do away with the fractions.
Yes, in my view, that would lower to 15 if we consider Senator Bato constructively resigned.
So again, just to belabor the obvious, Justice, if another member of the Senate were arrested because of an ICC warrant, it's still the same thing, right? That person cannot be deemed to be constructively resigned. So that person, even if detained, is still a member of the Senate. And so therefore, you cannot lower the number of the denominator.
Yes, that is correct. Even if it's arrested, detained, and even surrendered to the foreign court, as long as he remains a senator, it should be counted in the denominator of the 2/3 computation.
Justice, can we take a look at the other side of the provision, Article 11, Section 3, number 6, I think, right? From the perspective of acquittal, right? So if 2/3 is needed to convict, how much do you need to acquit? 1/3 plus 1?
1/3. If the total is what, John?
If the total is 24,
yes.
And how many votes do you need to acquit an impeached officer?
To acquit?
To acquit.
You don't vote to acquit. You vote to convict. And anything short of 16 will be an acquittal. That's how it works out.
I see. So it's not like if you are able to gather 9 people ready to acquit, then
Yes,
that would be another way of looking at it, right?
yes. The voting will be, are you in favor of convicting the respondent? And if it falls short of 16, then a judgment of acquittal will be entered.
Justice, what do you say to the argument that insisting on 16 as the 2/3 threshold of a 24-person Senate, even though 2 senators are not able to vote, are not able to make motions on the floor and all that, might actually place the Republic in danger, like in case of war or declaration of martial rule and so on. What kind of counter arguments are we looking at here?
The idea there, the reason behind this, why it's based on the total number of existing senators, is to make it a more or less fixed basis, because otherwise the voting threshold would be very easily manipulated by simply arresting and detaining senators, even on false charges that will exclude them already from the computation and make the conviction easier. The purpose of the provision is to make the impeachment difficult rather than easy to manipulate. And also because as long as a person remains a senator, he represents a portion of the electorate, and therefore to exclude him from the computation would be in effect to disenfranchise the portion of the electorate that he or she represents.
How many votes do you need in the Senate to remove a senator from the Senate, let's say for ethical reasons?
The same, 2/3 of all the members.
2/3 of all the members.
Yes, the same, yeah.
Justice, the rules here on the impeachment, why did the Constitutional Commission of 1986 use this, I think, similar set of rules, mainly from the previous constitutions?
3/4 before.
Was it? It was 3/4.
3/4, yes.
So it was in fact harder.
We made it easier in that sense, 2/3.
So
Yes.
can I get back to your earlier point, Justice, that perhaps if the intention of the CONCOM of 1986 was to make it easier, bringing down the threshold from 3/4 to 2/3, then maybe the emphasis on members of the Senate might be misplaced.
In my view, no, because while it makes it relatively easier from 3/4 to 2/3, it's still difficult because what is required is a broad mandate rather than a flexible mandate. Broad mandate to remove a high official. So 2/3 is still difficult, not as difficult as 3/4, but it is a supermajority. And it is based on a fixed threshold, which fixed denominator, which is all the members. So that makes it really still difficult.
Can you recall some of the debates revolving around the reduction in the threshold from 3/4 to 2/3? Was it really for to make it easier, or was it to make it less likely for another Marcos to rule?
It's really to make it less difficult, but still difficult, because even the vote in the House of Representatives used to be majority. Now it's only 1/3. So we lessened the threshold, but still relatively higher threshold than simple majority. So we made it a bit easier to emphasize the need for accountability, but at the same time we wanted a broad mandate rather than an easily manipulatable, easy to manipulate percentage.
I think it was, in fact, Father Bernas who described impeachment as offering a form of political justice. So it, like we said in the introduction, it can cut both ways. And I was struck by your mention earlier that you didn't want to make it easy for political opponents to put their adversaries in jeopardy. So that would be the political part of it. What can wait, before I ask this question about what the public can expect from a numbers game, I want to ask the arithmetic of resignation naman. What happens if the trial has started and then the Vice President resigns?
If the respondent resigns, there are two versions. One is that the proceedings must be dismissed because the purpose of the proceeding is to remove the respondent from office. And so if the respondent resigns from office, there is no more purpose. But that is not the only purpose. The other purpose is to declare the respondent disqualified from holding public office.
Okay.
And if that, even with resignation, that other purpose remains. So the other view is that the proceedings can continue in order to determine the other question, whether or not the person, the respondent, should be disqualified from holding public office. So there are two views. There's no precedent yet in the Philippines for that.
And the threshold remains the same, even if the respondent is no longer there. It's still 16 or 15 in the case of constructive resignation.
In the case of resignation, and if the Senate decides to continue the proceedings, you would still need 16 votes in order to disqualify the respondent.
Justice, what can the ordinary citizen expect from this very contentious political exercise if we, unfortunately, reduce it to numbers?
Yes, first of all, the senators are required under the Constitution to take a special oath before assuming their functions in the impeachment tribunal. And that special oath says only one thing, to be impartial.
Okay.
And so we should expect both, that they will act like political persons, and yet at the same time they are under oath to be impartial. So we have that balance that we have to look at, that understanding that they will not be completely impartial because they are political persons, and yet at the same time they are supposed to judge according to the evidence. So that is the two sides of the functions of a judge as a senator judge in an impeachment hearing.
It's a delicate balancing act, no?
Yes, that's very delicate, because they have their political nature as elected officials representing the people, but at the same time they are sworn to being impartial and decide according to the evidence. When the senators meet, when the senators convene the impeachment court, they will have to name a presiding officer. It does not have to be the Senate president, right? It can be anyone. It does not have to be. Only provision of who will act as presiding officer is when the respondent is the president. The Constitution says that the Chief Justice shall preside, but shall not vote. It's silent on who will preside in all other cases. So the rules of the Senate will prevail.
Would it be better if a lawyer were the presiding officer? So that's part of the argument why someone like Chis Escudero is being floated as the possible presiding officer.
Yes, that's possible. It's up to the Senate to choose. It doesn't have to be a lawyer, although a lawyer may be a good choice or better choice, but it's not necessary.
What would, okay, I think we can understand what a lawyer would bring to the table if he were to, a lawyer were to preside, no? But what would a non-lawyer be able to bring to the table if, for instance, Senator Win Gatchalian were to act as the Senate, as the presiding officer? What would a lay person be able to contribute?
Yes, on matters that may require legal knowledge, the Senate President, who is not a lawyer, may have assistance from a member who is a lawyer. Sometimes they appoint a manager that can assist the presiding officer in matters of legal issues that may be raised during the trial. So there's, I think this has been done before, a manager, also a senator judge, to assist a presiding officer. There's also the clerk of court, who has experience, vast experience in the present case of the present clerk of court, who has experience in matters of impeachment, who can officially, that's his job also as clerk of court of the tribunal, to assist the presiding officer. There is always the possibility, John. I was also presiding in the Constitutional Commission. And when there are difficult matters, or even for me as a lawyer, there are contentious matters. What you do is bang the gavel and say, session suspended, and then consult. Consult among the members what they want and what should be the proper procedure, how to proceed. And that's always a possibility. Just bang the gavel, session suspended, then consult.
Okay, so there's no real need for a lawyer like Chis Escudero to actually serve as presiding officer. Justice, why even have impeachment as a process? Why did you in the Constitutional Commission decide to continue the practice of impeachment? Why not, for instance, if you suspect a high official of high crimes, bring them to a real court? So here we're dealing with something sui generis, neither really here nor there. Why have impeachment in the first place?
According to my studies, John, impeachment is patterned after the United States, and in the U.S., according to Benjamin Franklin, they resorted to impeachment as an alternative to assassination. Because before, the only way to get rid of high officials who were undesirable was to assassinate them. So this is a more civilized way of removing high officials through a process called impeachment. That is what we have imported from the U.S. through the 1935 Constitution, impeachment. It is in turn borrowed from practice in England, where the legislative parliament could remove, not the king. Since they could not remove the king, they would remove his ministers. So that was the origin of the practice of impeachment in England.
Okay, I mean, I did not expect such brutal roots to this practice. Justice, for the ordinary citizen who might have the time and the inclination to follow the impeachment trial, what are some of the important moments in the trial that that citizen should look out for?
I think there are groups that are helping the citizens to monitor intelligently the proceedings of the trial. One of them is called Citizens Jury, in which Monsignor Sok Villegas has convened a group of jurists and legal experts to assist citizens by explaining in plain language what is happening and what could happen during the impeachment process. So these and other groups will be available to help our citizens understand the usually complicated process that is involved come July 6.
I think I've also heard of Bantay Senado, another civil society grouping. What can the Citizens Jury, Bantay Senado, and other groups do to make sure that the process itself is fair? No? As you pointed out, the judges sitting in the impeachment court are both political personalities and also people who have taken the oath of impartiality. So they have that fine balancing act. No matter what happens, what we want to see is a fair trial. It doesn't become an exercise in political persecution. So what can these groups do? What kind of pressure can they put on the Senate as impeachment court?
That's a difficult question to answer, John. To me, it's really because of the immediacy of television coverage and the fact that the proceedings will be covered by media, by instant television. I think our senator judges will be aware that the people are watching them. And so that will be a constraint always on their actions and decisions, that people are watching, people are monitoring their every move and every decision, which is, I think, a development that was not there before. The state of technology is so far advanced, and the social media, in addition to television coverage, you have the instant reaction in social media that can produce, I think, an effect on the central judges, who, after all, is answerable also to the electorate in the coming elections.
Justice, if the allies of the respondent, Vice President Sara Duterte, are already clear from the get-go that they will vote to acquit her, and that there may not be enough votes to convict, no? Regardless of the evidence presented. In other words, the political positioning is clear from the start and will not change, will not be affected by any presentation of evidence. Will the impeachment process still be valuable, or are we just going to waste millions of pesos in the next few months trying to reach a foreordained conclusion?
The way I look at it, John, is that the process itself, maybe whether or not the verdict may be already practically determined by the numbers, but the process itself will be unpredictable, as what happened in the case of President Estrada era, that the process resulted in something unexpected. So we cannot tell how this process will play out, whether or not it will reach the end verdict, or whether or not something else will happen in between, especially because of the volatile nature of coverage and social media. And people who are watching these particular proceedings, we cannot tell exactly what the people watching will do in case something that they feel is unfair transpires. So it would be best to allow the process to unfold in all fairness, in all to both parties, and regardless of the possible numbers, let the evidence unfold and let the people see the evidence. And so regardless of the verdict, the people will be able to judge on their own. Because aside from the senator judges, there's another judge, the people, and they are watching. They will have their own verdict. Regardless of what the senator judges will have a verdict, the people will have their own verdict. So what is important to me is for the evidence to be allowed to be presented as fairly and fully as possible so that the people can have a basis for forming their own verdict. Because in the end, if you go back to the first article of Article 11, the first section, is that public officials are accountable to the people, not to the Senate, but to the people. They are being tried by the Senate as representatives of the people. But in the end, the accountability really is to the people. And so what will happen during the proceedings, we do not know. But there's always the people behind the proceedings.
Justice, maybe just a couple more questions. No, we're talking about presentation of evidence. Let the evidence speak for itself. But what is the standard of evidence that we need to meet? No, this is not obviously a criminal case, so not beyond a reasonable doubt. How would an ordinary citizen understand how to measure the evidence being presented?
Yes, the quantum of evidence to convict is more than probable cause, but less than beyond reasonable doubt, in my view, because this is not a criminal case. It's really a broad leeway between probable cause, which is already there, because it is the determination of the House that there's probable cause. That's why they filed the articles. So we start with probable cause. But at what level can the verdict of conviction be justified? It's up to the Senate. The Senate will have their own appreciation, what they feel is sufficient to convince them that the respondent is guilty. And that is beyond debate. You cannot appeal that. Their own judgment of what is sufficient to convict based on the evidence is unappealable to the higher institution. It can only be appealable to the people. It's the people themselves will judge whether or not their verdict is acceptable or fair or just. But there's no definite measurement of the quantum of evidence needed to convince a senator.
Last question, Justice. No, I want to ask about the arithmetic of influence, no, or the arithmetic of one, no, one person, and that's the President of the Philippines. When you were discussing this provision in the CONCOM, was there a discussion about the role that maybe a too assertive president might play? What can the Senate do to make sure that they reach a decision independent of presidential influence? What role does the President of the Philippines play in such a highly contentious political process?
Actually, the Constitution does not provide a role for the President in the impeachment process of officials other than himself. No, the President should stay out really and let the institutions involved, which is mainly the legislature, do its thing. However, there may be occasion. For instance, if the Senate membership falls below quorum for one reason or another, the senators say only 10 remain. So you cannot have a quorum even to reach a vote. So there has to be special elections to fill the vacancy. Then the President will come in, because the President will have to provide, probably call the Congress to session, and somehow find a way to enact legislation to fill the vacancy where the Senate has no more quorum, how to have a special election law. In that event, maybe the President will have to resort to his emergency powers to call special elections to fill the vacancy.
Justice Adolf Azcuna, thank you very much yet again for helping shed light on impeachment and helping us do the math.
Thank you, John, and happy feast day.
Thank you. Thank you very much, Justice. And that's it for us today. The challenge for engaged citizens remains the same: to defend and to fully inhabit the democratic space, especially for the most vulnerable. Please download the Rappler Communities app and join the chat room of your choice. And if you haven't yet, subscribe to Rappler Plus. Thank you. This is John Nery. See you in the public square.